We're going to take this time to just take some deep breaths. So those just coming in, feel free to just breathe with me. 3 seconds in, 3 seconds out, equal breathing all through the belly. The belly should be rising and falling. All right, family. I'm excited. I'm excited for today. Today's video is going to be truly transformative for a lot of people. It's going to give a lot of people great insight on truth and lending, the power of truth and lending, the power that we all hold, the power that's within these contracts as well. So I'm going to show you guys how to find the fraud within the contract alone itself on this call. And I'm going to show you guys how to exercise your guys' right to rescind this, any contract, within a 3-year time frame as well too. I'd gone over a case law study within the Supreme Court, so this isn't just something in which Tone has gone through, Credit Gotti has gone through, and just learned from a book or from the internet. It's something I've actually gone through in an affidavit I'm going to read to you guys today that I was able to get removed from when back 2 years ago. This is what got me into learning consumer law. When my car had been repoed, I had exercised my right to rescind the contract and my right of rescission, and I got it removed fully from my consumer report, and now I'm going through the process of getting remedy from them upwards to 50,000. So today's call is going to be powerful. I've just literally been traveling the past year and a half. I haven't been able to literally even sit down to file my federal complaint, but I'm about to be back in Arizona, which is the place of my abode, and on Thursday. So looking forward to getting back to America and really getting in tune with you guys, really showing you guys more of what we have going on just as a whole. But today specifically, like I said, is going to be very powerful. A lot of people have heard of the right of rescission. I'm going to break it down to where, anybody, whether it doesn't matter what level you're at in consumer law, is going to be able to understand, how to break down this information that I'm going to provide to you guys. So make sure you guys got your notebooks out. I believe this law specifically is the most powerful within all of truth and lending as a whole. So let me pull it up. I got a couple letters for you guys as well too. I see you, my guy Justin. My guy Justin's tuned in. I got a couple different templates, and then I'm going to read an affidavit I've sent out, and that got this fully removed from Equifax, Experian, and then it took a little while for me to get it removed from TransUnion. It didn't right away come off from TransUnion. I had to go through the arbitration, process with TransUnion to get it removed from TransUnion. But specifically, the affidavit did get it removed and fully discharged from Equifax and Experian, but they were still just reporting it on TransUnion. So I just went through with TransUnion, took them through the arbitration process, and I finally got that removed. After about 3 to 4 months following it being removed from Equifax and Experian. So I'm going to show you guys this specific letter I used, and I'm going to just show you guys how to really break down and interpret all of 1635 as a whole. So let's get into it. Where's everybody tuned in from? Drop what city you guys are tuned in from. If you guys are excited for this information, make sure you guys come in here. And if anything ever clicks, you guys get a download, you guys get a breakthrough. Make sure you guys just like this video. And that's all I ask, and share this with 5 people as well too. If there's something you guys don't agree with or don't like, or you don't like the content, I simply ask you drop a dislike. It takes just as long as it takes to like, but also make sure you comment some things in which I can add going into the next videos, so that I can make sure that the people in the future don't deal with the same things in which you guys didn't agree with or like yourself. So let's get into it. There's going to be some heavy information. I hope you're all ready. So I highly advise everybody pull up cornelllaw.edu, come to 15 USC 1635. I wish I could share my screen. I'm sure there's a way of doing so. I'm just not sure how. I would love to see as well too, throughout this live, if you guys are getting any breakthroughs, for anybody to drop a super sticker as well too. The super stickers would be highly appreciative. The super stickers or anything in the super chat I'll also DM you guys or message you guys, my business number, and then send you guys an ebook of ours, one of our business credit ebooks for anybody that drops a super like or a super sticker. But coming in here, let's drop right into 15 USC 1635. For anybody just tuning in. So coming here right away, the name of the code itself says everything. It's your right of rescission. It's not a privilege, but it's your right. So this is, anytime we see a right, it's something that's God given, is something in which cannot be taken away from us. Once again, it's not a privilege, this is our right, and we have at any time the ability to exercise our rights. As a natural person, we at any time can exercise our rights. So A talks about the disclosure of the obligor's right to rescind. So whom is the obligor? In the chat box, does anybody know whom the obligor is? All right, the obligor is the organization. All right, so if you guys remember me breaking down in Truth in Lending in 1602, the definitions of the term person is a natural person or an organization. Remember, being a natural person, you have the ability to act on the behalf of either the natural person or the organization. So if you remember me talking about how powerful it is, anytime you guys see in law the word or, that's giving you guys the ability to choose. That's giving you guys freedom. Right? Anytime you have the option to choose, that's freedom. So anytime you guys see the word or, it's giving you guys, and you guys are going to see this in today's specifically as we break down the right of rescission. So make sure you guys pay very close attention to the word or. As a lot of people think, the right of rescission only applies for 3 days. It states or, and it's going to, state something that's going to open a lot of your guys' eyes. So make sure you guys are tuned in. Make sure you guys are coming in here, liking the video and sharing this with 5 people as well too, so that more people can get access to this information, so that we can put these dealerships and all of these lenders in place, so that they're not violating us, misleading us, and deceiving us, and abusing us with all of these payments. So remember, as a natural person, as a person, you have the ability to act on the behalf of both. You have the ability to switch between both. So always remember that. So it states within here, except as otherwise provided in the section, in the case of any consumer credit transaction. So notice how it states any consumer credit transaction. We remember what a consumer credit transaction is. All right, consumer credit transaction is anytime your credit card is ran. Right? I'm going to break down one of my students' letters as well too, and where they break down all this terminology within a letter as well too. So I'm not going to just show you guys something I've exercised, had success myself with. This is back in 2022 as well too. But my mentees have gone through and had success with this as well too. After getting a lot off the card, no down payment, and then going and rescinding the contract and then not making any payments afterwards. So I'll show you guys here the letter in which they had sent out. So any consumer credit transaction, including opening or increasing the credit limit for an open-end credit plan in which the security interest, including, notice how they mentioned the open-end credit plan, in which a security interest, including any such interest arising by operations of law, is or will be retained. Notice how they state, or acquired in any property which is used as the principal dwelling of the person to whom credit is extended. The obligor shall have the right to rescind the transaction. Notice this right here, until midnight of the 3rd business day. So this is why typically people think, oh, after 72 hours, I have 3 days to rescind my contract. If I don't rescind it after, I'm not able to rescind it. That's not true. All right, so it states right here, or the delivery of the information and rescission forms required under this section together with the statement containing the material disclosures. So they're supposed to provide this to you. They're supposed to disclose this to you. And if not, you have until the delivery of your rescission paperwork and until they've disclosed this to you. So, they've never disclosed this to you. So this is how in that case law study within the Supreme Court, Janowski, Jesenowski, I never know how to pronounce her name, versus that mortgage home company. This is how she was able to win after the 3 years, because they never delivered her rescission paperwork to where they were able to rescind, because they never exercised their right. And after going through the contract, breaking it down, they finally found fraud within it. So let me see. I got a couple notes jotted down here. Let me see if I'm missing anything. Notice as well too. So if we come here to this part where they talk about in which a security interest. So the security interest, what they're mentioning right here is, and some things I want you guys to mention as well too, we can hold them criminally liable because before even holding them and notice how within truth and lending they talk about holding them criminally liable before even holding them civilly liable in Title 15, 16, 11, because they're supposed to disclose this information to us, and for them knowingly and willfully holding this information from us and not disclosing it to us, then we can hold them criminally liable and pursuant to 15 USC 1611. Let me pull this one up for you guys and read this out to you guys. It states whoever willfully and knowingly gives false or inaccurate information or fails to provide information. So as I mentioned, if you guys go back, I'm giving a lot of subtweets with a lot of the subtweets. I'm giving a lot of the insight just as a whole. And all of the information will correlate if you guys go back and watch the videos, as I broke it down already, this code as a whole. But I mentioned, if they fail to provide information which he is required to disclose under this provision, they're required to disclose this information, for them knowingly and willfully, holding this information and not providing it to us, we can hold them, criminally liable, and they can be, fined for 5,000 or imprisoned for not more than a year or both. And this is what is stating within Title 15, 1611. And this is holding them criminally liable before even holding them civilly liable. And within this subchapter as a whole, in 1640, it talks about not only $1,000 per violation, but it's double the finance charge per violation. So the finance charge that has arose from your guys' credit being ran, is double the finance charge per each violation. So this is why, through auto loans, through mortgage loans, there's a lot of remedy, within these contracts with you guys going through and breaking it down. Let me see. Okay, beautiful. So remember, family, we talk about holding them criminally liable, prior to even, for them not disclosing this information, for them failing to provide information in which they're required to disclose to us. My God, G Lopez, he's already gotten results. You've already gotten results from what, the channel, or consumer laws from Truth and Lending? What specifically have you already gotten results from? My God, G Lopez. My God, Mark James, sup fam, we should talk when you have some free time. Feel free to schedule a link. I dropped the link in the description. You guys all can schedule a one-on-one 15-minute high-level conversation through there. Also, it'd be, highly, it'd be highly recommended for each one of you guys to get within one of the membership levels as well too, as all of the content is being uploaded today on the channels. So make sure you guys are tuned into the membership levels. All right, and let me see. So let's get back into 15 USC 1635. We're still on A. So the obligor shall have the right to rescind, okay, or the delivery, so that 3 days or the delivery of the information and rescission forms required under this section, together with the statement containing the material creditor, in accordance with the regulations of the Bureau of his intention to do so. Check this out as well. So the creditor shall clearly and conspicuously disclose. How many of them clearly and conspicuously disclose in accordance with the regulations of the Bureau to any obligor in a transaction subject to this section, the rights of the obligor under this section? So they're supposed to disclose to you guys your guys' rights, under this subsection, in which they don't. So the creditor shall also provide, in accordance with the regulations of the Bureau, appropriate forms for the obligor. So once again, remember, in this instance, as a natural person, you have the ability to act on the behalf of, yes, the natural person or the organization. So in this instance, we are the obligor. For the obligor to exercise his right to rescind any transaction to this section. So now this is where it really gets powerful in B. So in B, it's a return of money or property following rescission. So something that you guys can send out to them to, put them on notice that you are exercising your right to rescind. And I highly recommend that each time you do send a rescission letter, you guys are sending it in, with a notary public. So you guys are getting it notarized. You guys can go get something notarized completely free. from anybody you're banking with. I highly recommend going with the credit unions, and going and setting up, if you don't already have that Navy Federal account, going to set up that Navy Federal account, in which I'll show you guys how to set up. If you guys are looking to get that Navy Federal account set up, I can show you guys how to do so for $100. So check this out. I'm going to show you guys, the first letter in which you guys would send to them to put them on notice that you're exercising your right to rescind. And so notice to principal is notice to agent. Notice to agent is notice to principal, putting them on notice. I'm writing to you in pursuant to 15 U.S.C. 1635A, the disclosures of the obligor's right to rescind. I'm hereby requesting in good faith and honor the information and rescission forms required under this section, together with the statement containing the material disclosures required under the subchapter, in accordance with the regulations of the Bureau. Then I define how the creditor shall clearly and conspicuously disclose, in accordance with the regulations of the Bureau, to any obligor, just what I had read to you guys, and then how they should also provide, in accordance with the regulations of the Bureau, appropriate forms for the obligor to exercise his right to rescind any of the transaction. Then I'm going to put the creditor's name, whom it is, is ignorance of the law is no excuse. These disclosures are mandatory under Truth in Lending, 15 U.S.C. 1635, and you have 14 calendar days for the receipt of notice to provide me with all my Truth in Lending disclosures under Title 15 U.S.C. 1635A. Simple as that. I'm going to have it notarized, subscribed and affirmed, having been duly sworn to and at the city before me, the notary public, for the said county, as stated above. Noted, do hereby state that the living man, blank, personally appeared before me and signed the foregoing instrument. Then you guys are going to sign it. The notary public's going to sign it, and you guys will get that notarized and have that sent off. I'm going to show you guys a notary, an affidavit I sent off personally. So I stated I mailed a cease and desist letter and a validation of debt letter, as well as a CFPB complaint, breaking down. So let me read it to you guys properly. Personally appeared before me, the undersigned, authorized in and for said county, state, blank, my name, my, first name, hyphen, middle name, full colon, the last name, comma, beneficiary. I'll put it at the time. And I just put, last name, period, UCC 1-308. The undersigned affiant is over the age of 18, and on the date I mailed a cease and desist, validation of debt, CFPB complaint. They were both simply pointing fingers, and neither were holding themselves liable. I continue to exercise my right, because all the dealership was saying is, it's on the lender, it's on the creditor, and the creditors were saying that, it's on the dealership. So they were just pointing fingers. So I continue to exercise my right to rescind, because I was never disclosed in my right to do so, and it has been so within 3 years in pursuant to 15 U.S.C. 1635F. I've never even went to the extent to filing an OCC complaint. I even went to the extent of filing an OCC complaint a week ago, and they continue to violate my consumer rights and laws, as they've been calling my mom. I never gave them her number, which is an invasion of my privacy in pursuant to 15 U.S.C. 681, number 4. And I define what's private to me and what's not. They also have been acting on the behalf of a debt collector, as they've threatened to take property from me for paying an alleged debt, and where I credited them every month. I have my consumer open-end credit plan that will even show that every month I extend Westlake Financial Credit. I'm seeking litigation for all of my rights in which they have been violated, and for the poor ability to respond, as this is going to be my second affidavit and second letter that I've sent, certified mail, a copy of which is attached to this affidavit and marked Exhibit A to the address set forth by deposit in pursuant to 15 U.S.C. 1605. They've charged me outside of the finance charge. So breaking down all of that, breaking down the finance charge. Then I break down 1635 even more. They also proceeded to take advantage of me, taking down a down payment, broke down that. They also gave false information. So I broke down 1611. Then I broke down 1635. Then I break down. I've been in contact with Westlake, and they put blame on the third party dealership. And my truth in lending disclosure, the finance charge was blank, and the total sale price was blank. And they have taken unjust advantage of me, and I'm holding these companies civilly liable in pursuant to 15 U.S.C. 1640 and 1611 for the unfair acts that they have reported and assumed over my credit, over my life, in quotation marks, credit. It's very obvious they have informally used my credit, uninformedly used my credit, and that the car was paid for the moment that they got my credit card in pursuant to 15 U.S.C. 1602. And then I defined the term credit card. From the moment they received my credit card, the vehicle was paid as shown in the amount of the finance charge. In the amount financed, blank and blank acted unlawfully and violated my federal rights after being credited. After already being credited, then I get it signed by a notary public and I autograph it myself. So that's what I went through. This is what I did way back when. This was in what? February of 2022. So over a year ago now, in which I had done this and gone through, got it removed from my report. Um, so wanted to come here and read to you guys things of which I've done self, things of which my mentees have done. So I'm going to read to you guys now B, and I'm going to read to you guys next a letter my mentees created and success he's been able to, get and walk off like that. Like I said, the lot with no down payment. And then a week later, he exercised his right to rescind and now had no payments as a whole from these letters in which he had sent. So I'm going to just show you guys one of the letters and the first letter he sent out. Let me see. How do you liquidate a business card? We're going to stay on topic. I'm going to go over some business credit stuff this week, though. You should do live questions. You should do live questions live every day. Okay, I'll definitely add that as I get back to America. I'm definitely going to be doing that. And I'm open to Q&A, so I will definitely do that. We could do what? Yeah, we'll get to it. We'll definitely make that happen. Let's get some more likes, though. If you guys are coming in and liking the content, liking the value, let's like it. I have 10K, 11K, for sure. Yeah, King, I'm open. I'm a student, bro. Let me know. I'll go live. We can go live together. We can answer questions together. I'm all for, building, with one another. So B, check this out. When an obligor exercises his right to rescind under subsection A, he is not liable for any finance charge or other charge and any security interest given by the obligor. All right, ask yourself, what does that mean to you guys? Right, it means you don't owe any finance or other charge if you exercise your right to rescind. If you exercise your right to rescind, that security interest becomes null and void. If you exercise your right to rescind, the security interest that you guys gave to them through the contract, that if you look at the truth in lending disclosure, look right under, I've been saying this now for the past couple of videos. If you guys look right under the truth in lending disclosure, it's going to say you are giving security interest in this vehicle. You guys go through, you sign it, you guys gave it away. If you exercise your right to rescind, it becomes null and void because you were deceived and misled into signing in, something in which you had nothing, about, you didn't know anything about. They didn't clearly and conspicuously disclose this information to you guys. So you don't owe any finance or other charge if you exercise your guys' right to rescind. My back hurts. Come on, y'all. Who's with me? Who's with me? Who's with me? All right, family. So check this out. So any such interest arising by the operation of law becomes void upon such rescission. Within 20 days after the receipt of notice of rescission, the creditor shall return to the obligor any money or property given as earnest money down payment or otherwise, and shall take any action necessary. So if they don't take any action, within the 20 days, if they don't come to collect the vehicle, if they don't come to collect any payments, if you don't hear from them after the 20 days, right, you've properly done and, sent in the rescission forms. That's why I highly advise you get it, notarized by a notary public. You also send it certified mail to them. So now you got them, in a contract. Now you got the contract number in. So upon rescission, everything becomes void upon such rescission. Within 20 days after receipt of a notice of rescission, The creditor shall return to the obligor any money or property given as earnest money, down payment, or otherwise, and shall take any action necessary or appropriate to reflect the termination of any security interest created under the transaction. If the creditor has delivered any any property to the obligor may retain possession of it. If the creditor has delivered any property to the obligor may retain possession. So it means you may obtain possession and you are not liable for the payments upon rescission. I'm not saying this. This is what it's stating within. This is what Congress is telling you guys. Upon the performance of the creditor's obligation under the section, the obligor shall tender. All right, y'all gotta understand what legal tender is. Shall tender the property to the creditor, except that if the return to the property in kind would be impracticable or inequitable. So if it would be impracticable or inequitable, also within your rescission letter, break down how it would be impracticable or inequitable if they were to seize the vehicle. If they were to take the vehicle from me, the vehicle's already been paid for. Also you want to mention within there how it would be impractical or inequitable for them to take the vehicle or the property from you. This, vehicle takes me to and from work, to provide and keep how a roof over the head, for a roof over me and my family's head, and food on our kitchen table. Without this car, I'm not able to get to and from work. I'm not able to take my kids to school. All right, so break down how it would be impracticable and how it would be inequitable. All right, so because it states right here, upon the performance of the creditor's obligation under the section, the obligor shall tender the property to the creditor, except that if the return of the property in kind would be impracticable or inequitable, the obligor shall tender its reasonable value. Tender shall be made at the location of the property at the residence of the obligor. We don't even have a residence. We don't reside anywhere. Right, like I mentioned earlier on the call, place of abode. Right, it mentions that also within the FCRA. Go look up 15 USC 1681A. At the option of the obligor, if the creditor does not take possession of the property within 20 days after tender by the obligor, ownership of the property vests in the obligor without obligations on the part to pay for it. So, like I mentioned, upon you rescinding, the contract, exercising your right to rescind after 20 days after tender by the obligor, ownership of the property vests in the obligor without obligations on the part to pay for it. The procedures prescribed by this subsection shall apply except when otherwise ordered by a court. So now check this out. So a lot of people think, oh, three days. You really want to do it within. There is a time limit for exercise of your right of rescission, and if you scroll down to F, it'll define an obligor's right of rescission shall expire 3 years after the date of consummation of the transaction or upon the sale of the property, whichever occurs first, notwithstanding the fact that the information and forms required under the section. So check this out first. It says an obligor's right of rescission shall expire 3 years after consummation or upon the sale of the property, whichever occurs first. So you have 3 years or upon the sale of the property, whichever occurs first. So typically you guys have that 3 years, or also remember, you have until the delivery of your rescission, documents in which they don't provide to you guys on your guys' behalf. So I gave you guys 2 different affidavits you guys can go create, and send off to them. You guys can start your process today. What you guys want to do is, once again, create it affidavit style. Also, you want to get it notarized. You guys want to have it certified mail. So you want to have a copy for yourself. You want to have a copy that you're going to send to the dealership, a copy that you're going to send to the bank as well too, to the lender. Always keep a copy for yourself. Get all 3 notarized as well too, so that you keep record and evidence of you going and getting that notarized. You got that paperwork with you. You got 3 of them. You send them 2 of them off, certified mail to the bank and to the dealership. From there, they're gonna wait for the response. You'll have the 20 days upon rescission. If you don't hear back, I don't advise you stop making payments at all until you guys fully get it discharged and you guys get in the mail, them zeroing out the account, and you guys will get in mail. They'll send to you guys that the account is zeroed out. They'll send you guys a receipt of it and whatnot. So yeah, family. that's everything as far as a rescission step by step. We will be going more in depth within the Billionaires Club, so I highly do advise we'll have more templates. I got a lot more for you guys, a lot more step by steps, a lot more in depth as well too within the right of rescission. I did break it down to the T. Now I truly don't believe I could have broken it down a better way for you guys. I just highly advise if you don't understand it, go study the definition section of the Truth in Lending 1602. And make sure you guys just watch the recording and then watch the past couple videos I've done as well too, because they do tie into this one as well too, with holding them criminally liable, with them talking about and withholding information and not properly disclosing information, they can be held criminally liable. This is before we even get into the right of rescission. And then after rescission, we talk about holding them civilly liable for double the finance charge. So we're not talking about no small money. We're talking about big money. Go look up your finance charge, and we're talking about double the finance charge. We're talking about upon the right of rescission, the security interest in which we gave them from us unknowingly and, being deceived into signing this contract, now becomes null and void. Now we're taking back security in the vehicle in which we obtained from the beginning, from the first, something bit my ass. Something bit my ass. Ow. All right, that's Mother Earth telling me we about to wrap it up. Last couple of days in Canada, so I'm about to go explore. We're gonna be back on road Wednesday, and we'll be back in the city Thursday. So, little day trip. I'm gonna take a couple stops elsewhere, private locations, before I head home. So I'm excited. Just discovering this information over the last few weeks. Then I ran across your channel. Very thankful for what you're doing and looking forward to mobbing. Yes, sir. Knowing how to operate within this game of commerce, knowing whom you are, knowing the rights and scripture, not only just the Bible. I'm not a Christian. I did grow up Catholic. Me now, I am spiritual. I'd say I'm not any religion, but I do believe there's truths within all religions, within each one of these, books. But I also believe, you know, there's also lies within them. There is duality to everything, and I go into the hermetic teachings. I go into the esoteric knowledge and the esoteric teachings. And I was talking a little bit about the hermetic principles on, I think it was this Saturday. And so the 7 hermetic principles, they tie into everything we're teaching within consumer law as well too. We had just done within our community. If you guys aren't in, my public Discord, I do highly advise you get in my public Discord. My goal, my mission is a billion lives. It's not just going to be empowering people, with this information in consumer law. It's going to be helping people mentally. It's going to be helping people spiritually. It's going to be helping people, physically, getting in shape, eating better, eating high vibrational, foods that are actually feeding our body on a cellular level. Right. And so tapping back into the ancestral ways of living, dancing, singing, all, breathing properly, all of these things in which we've forgotten to do. That's my movement, and that's what I'm about, and that's how we're going to empower a billion lives. So yes, the consumer law stuff is vital, but if you're not taking care of yourself elsewhere in all areas as well too, none of the information matters. And a lot of people I've seen within this community do get so consumed within this information. So don't let it consume you. Take an hour or two a day to learn this information. Study it up, read a book, have a mentor within this, but also invest into more mentorship and more guidance. But I wanted to cover real quick the 7 hermetic principles. I'm not going to dive into them. All of you guys can go read the Kabbalion. It is a great book, a great read. And this is a hermetic teaching, a hermetic, tablet that's out there. And this comes from the Emerald tablets. Laptop is running low, so we got to slide. But the principle of mentalism is the first principle. The principle of mentalism, the principle of correspondence, the principle of vibration, the principle of polarity, the principle of rhythm, like I said, dance and singing, the principle of cause and effect, and the principle of gender. So I highly advise everybody go look into the 7 hermetic principles, as these do tie into everything in which I teach within consumer law as well. So I also highly advise everybody go look into Deuteronomy 15, the book of Numbers, as that ties into everything we're teaching within Title 15 as a whole as well. We'll cover a lot more titles as a whole. Before anything, I want to make sure we all got Title 15 down pat. We've gotten results on it. I don't want to keep coming here and for you guys to keep coming here and hearing about the same information. I want to drop at least one video per 1 to 3 videos per each account, and or derogatory account or situation in which most people are going through and attacking, whether it's auto loan discharge, whether it's you know inquiries, whether student loans. 1 to 3 videos, you guys watch those 1 to 3 videos and are getting results, so that now we can build from there. Now we can go acquire funding, now we can get remedy from these corporations, and now with the funding we can truly properly invest. And that's what we're really focusing on in 2024, is building businesses and investing and buying businesses, buying commercial property. And that's the focus going into 2024, is building businesses and buying commercial property. And so that's what we're focused on, and that's why we're building the community of people that can do for self. That's why I'm teaching you guys this information. So I'm not holding back any information, and the information in which I am teaching is for a reason, and it's for you guys to go out and apply for self, do for self, so that we can get our finances in order, receive the funding in which we all deserve, and all have access to. And now once we receive access to this funding, now we can go properly invest it within the financial markets, within the real estate markets. You guys can be buying gold, actual money. Everything outside of gold is literally credit. The only proper money, and the only money that's even a part of the Constitution as a whole, and the only legal tender is gold. So even buying your houses with gold, I don't specifically teach that, but going through and learning about that, I'll give you guys some individuals in which you guys can learn from in regards to that. If you guys are homeowners, just reach out to me, set up a call. I'll give you guys information and insight on all of that, or get plugged into our public Discord. Within there, we're dropping information daily. Like I said this morning, we had a great call of the 7 laws of the universe, from our mindset mastery coach, who's out here. Actually, she's from Canada, and she's been hosting them every single Monday. So if you guys have felt like you're in a slump, these Monday mindset mastery calls will help each and every one of you guys. Oh, let's see how to be in the Discord. Let me drop the link right now. But I am about to leave up out of here from there. I may go live a little bit later on today. So make sure you guys are just tuned in with the Discord. Let me drop in here. I see my guy Zay X said he's about to join Billionaires Club right now. I'm excited to have you a part of Billionaires Club, Zay. Where are you tuning in from, brother? Are you going to post this? I missed the whole thing. Yes, this one will be posted. All the lives will be posted. I don't find no point in going live and not posting it. I feel on each time I come up here, it's the least I can do to just leave it here for y'all, because we ain't gonna be here forever. I promise you that. We're not gonna be on the YouTube forever. So let's run up the views, let's run up the streams, let's run up the channels, let's get this success, let's get the results, and let's get off the YouTube and let's build in person together. Let's build our own communities. Let's build our own private communities, our own private streaming platforms, our own everything. I don't want to be operating off none of this public stuff. So let's get right, y'all. 1 billion lives. Let's get it. Peace and love. We out. I'll drop the link for the Discord in there. Are you going to believe I answered everything? Yes, sir. I did. We out. Bow.